We are fortified by the holding of the minority judgment. It is clear that the matter that was presented to the court was meritorious. It was based on fact and based on law. So we are not as happy as we should have been had the majority ruled in the manner that the minority ruled. However, this has been an exercise which has been very important for the development of jurisprudence. I'm sure that members of parliament will reflect upon the provisions of those articles in the Constitution so that there is no similar absurdity in the future. And I'm hoping that soon this decision will be revisited, because if it's not, it's going to create a very bad precedent that the ECZ can decide at will to ignore the fact that people are withdrawn from participating in an election. Article 52.6 is very clear that when a person resigns, the ECZ has no choice. As the minority judgment said, they are mandated by law, they are compelled by law to cancel elections and call for fresh nominations. That is the position that we stand. But of course, the majority judgment is what shall oblige all of us. But we still believe that the minority judgment was the correct judgment. Thank you.
We'll invite the petitioners, Isaac and President Sinkama, to speak as well.
Well, we see it's a court which is not very, very important in this country. In fact, it's one of the most important courts because it's handling the supreme law of the land. But you see, why there is discontent is because the court is failing to deal with matters in a more authoritative manner. You know, if you look at this matter, it was coming up on Monday for judgment last week. And the issue of resignation and the decision, in fact, the decision came afterwards. You're supposed to have delivered the judgment. But because there were some underhand methods which were used to try and coerce the outcome, we have this decision which is not even very clear from the majority. They have not indicated whether those candidates who had resigned would be eligible to contest in the election if it was to run again. They haven't indicated that. Secondly, they have made another serious omission, in our view, on the interpretation of Article 57 and Article 56 on the 30 days. When does the 30 days start running? The 30 days which they are talking about started running on the 12th of September and 13th of September. Okay, so if there was supposed to have been an election as a result of the 30 days which they are talking about, that election would have been held on the 12th and 13th of October this month. Understand? So to tell us that the vacancy is going to be created because of the resignation, the question is when is that vacancy going to be created if it's not created upon submission of the resignation letters. So already now we are in suspense. We don't know at what point the resignation letter is valid. And when is this resignation letter taking effect? So we have what has happened now is to create more confusion on the letters of resignation, because for us we were very much fortified that it is upon receipt of that letter that's when it takes effect. But what they're telling us now is that it's not known when the resignation takes effect. And it becomes very, very unfortunate if we are going to proceed in this manner, because resignations will be always there in future, and we may have problems. Secondly, we have a situation where a time frame for election is stipulated in the Constitution. For example, the general election is going to, for the next one, it will be on the 13th of August 2026. So suppose there is a stay from a high court on a particular manner, or there's a stay in the constitutional court because some candidate has issues, will that date be moved? What this court is telling us now is that that date can be moved depending on the stay. That someone can stay an election, a general election is supposed to be held because someone has an issue, therefore the election cannot take place. And this is where we have a problem ourselves, where we start now giving excuses on the time frames that are in this constitution. Those should never be moved. We have an issue in South Africa, for example, where because of COVID, the various parties there wanted the election to be shifted by 6 months or so. The Constitutional Court refused. They rejected. They said the time frame which is in this constitution can never be changed. So whether there is COVID, there's what, you have to proceed with the election. And indeed, they went ahead with the election. And that's how we need to handle this matter. But the moment we're going to start skirting around, and with no proper reasons, we shall just create chaos in the electoral system, and we don't need that. And we agree with the dissenting judgment, where she's talking about creating chaos if we're not very careful how we manage the electoral process and that definitely will create problems. Because we are going into Kabushi and Kwacha. Let's see what happens.
Your brother here also is very excited about the minority judgment.
Thank you.
Honorable George Sally.
Thank you very much, Ambassador. I think for me first is to also show accolades on the petitioners. I think they took a very brave step to come to this court to seek an interpretation of certain events that took place. That is how it's supposed to be, because everybody has been thinking that this is a matter of the Patriotic Front alone, and people are calling us crybabies. President Sinkamba and Mr. Isaac Mwanza are activists, and they came to this court, which has been set apart by the Constitution, to interpret, as it were, what should be done in the event that people have a conflict regarding the applicability of the constitutional provisions, especially in the electoral process. I would like to urge Zambians, including the ECZ, to take a leaf of the stern warning that the minority judgment gave to ECZ. They have been very reckless in how they've been managing elections in this country, especially beyond 2021. Because what you have seen is even why we have come to court so many times because of the Kwacha and Kabushi by-election and even other by-elections. It's because people are dissatisfied with the way the Electoral Commission has been conducting itself. Legal counsel for Electoral Commission was in that court. I would urge him to go and share the reasoning of the minority judgment on how ECZ must conduct itself with integrity, because according to the judge, she said the way the ECZ is managing elections in Zambia is a recipe for confusion, for anarchy, and even for violence. Violence is very easy to arise in the electoral process if it is not managed properly, especially by an umpire institution such as the ECZ. So for us as Patriotic Front, we are very happy that the minority judgment pointed out one